case briefs, and so much more. LSData's got what you're looking for.
The Supreme Court of the United States recently revisited an intriguing case involving business competition and a group of regional supermarkets named Topeo Associates, Inc. This cooperative association, which operates as a purchasing agent for its members, was embroiled in allegations of conspiring to divide marketing territories, actions that potentially contravened an integral part of U.S. competition law, the Sherman Antitrust Act, Section 1. The government argued that the association's practice of parceling out markets between grocery chains, coupled with various symbolic and operational restrictions detailed in Topeo's bylaws, contravened the Act's provisions which discourage agreements that limit competition and disadvantage consumers. This ultimately triggered the government's decision to approach the district court for injunctive relief. Initially, the district court sided with Topeo in a ruling that raised eyebrows and prompted an appeal by the United States to the Supreme Court. In what could be considered a twist in the tale, the Supreme Court, in its review, deemed that the district court's ruling relied on an improper analysis, warranting a reversal of judgment. Elucidating its stance, the Supreme Court contended that Topeo members themselves should have the right to determine their engagement with other supermarket chains, given the backdrop of competition in Topco-brand products. They strongly disagreed with the association's attempts to limit competition among its members, dictating that the Sherman Act does not provide scope for such restriction and territorial constraints on both retailing and wholesaling of Topco-brand items have to be abolished. Further dismantling Topco's protective strategies, the court declared that customer restrictions on whom its members could sell their goods to were impermissible, as it curbed intra-brand competition and nurtured inter-brand rivalry. Following these precedent-setting interpretations, the case returned to the lower court to allow for the entry of an appropriate decree. It's worth noting that Justices Powell and Rehnquist abstained from participating in this landmark decision.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.